Hello, everyone. Welcome to our webinar. We are going to let people trickle in here for about 1 minute or so before we get kicking off. And we just want to welcome you all here. We really appreciate y'all being here. So as we are sitting here waiting to start off, I want everyone to think of their happy song. And by happy song, I mean when you have the client that drives you the most bonkers and they give you a call. What song would you put on afterwards to relax yourself and refocus after they have frustrated you? So put it in the chat. Think about your happy song. And like I said, we're going to get started here in about 1 minute, give or take. I see a lot of people coming into the room. So we're going to let everybody get in. Feel free to put it in the chat. I'm sure all of y'all have pleasant clients and none of y'all have those headache ones. But what is your happy song? What song do you play when you are upset with a client? So, all right, it is 1 o'clock. We are going to get going here. I really appreciate everyone being here. We have a great webinar today on how to avoid legal liabilities when working with property owners and investors. So we are very blessed today to have Monica with us. She is an excellent speaker. I had the chance of seeing her in NARPM a few months ago, and I just want to introduce her to you. She is a trial attorney with over 30 years of experience in real estate and property management. She's a frequent and popular national speaker on all aspects of property management, including best practices, fair housing, litigation trends, teaching real estate agents, brokers, and property managers on ways to reduce their legal liabilities. She is headquartered in Atlanta, Georgia, and her law firm often is called to handle real estate matters, brokerage and property management litigation, and tons of compliance work. So thank you, Monica, for being here. We are truly blessed to have you presenting to us today.
Well, thank you so much, Ben, and welcome to everyone. I'm so excited to have so many of us joining all across the country. I'm excited for this opportunity. It's going to be a great hour.
Perfect. Well, what we're going to do now is we're going to jump into the agenda so everyone here knows what we're going to cover, and then we're going to hop right into it. So we have a hard stop today at 3 o'clock. Monica is got to be somewhere, so we are going to be ending right at 3 o'clock. We got a lot of content that we're going to get through. But real quick, I want to just make some notes on the audience and what content we have here and who it's relevant to. So for our property managers, there's going to be tons of great content here on legal liability. All of this is going to be in your wheelhouse relating to when you're managing when you're managing your clients and responding to things. For listing agents, we know that you don't necessarily represent the maintenance and the in-between of leasing, something going on the market and getting the tenant in. However, there are topics in here that if you're working with an individual property owner, they might ask you a question around. So it's worth just having this in your arsenal as just some information that you might want to be aware of. So what are we going to cover today? We're going to go over Fair Housing 101, and it's going to go over some common risks and best practices. We're also going to go over a few best practices to avoid liability when relating to maintenance of properties and how to basically avoid common problems. And then we're also going to go over your leases and your property management agreement just a little bit, and we're going to talk about some specific language that you can use within there. So real quick, I got to say this, nothing in this presentation, whether oral or written, is legal advice. It shouldn't be relied that way. It's only meant to be educational. If you have specific legal questions, we encourage you to reach out to your broker or an attorney in your state. So we just got to say that everything here is educational. So we're going to jump into it, and we're going to start with Fair Housing 101. I know there's a lot of concern around working with investors and property owners relating to fair housing. Monica, can you give us a quick 101 basically on what fair housing is and who it relates to?
Absolutely, Ben, and you're absolutely right. It's something that we need to be very careful about is in the real estate industry. So the Fair Housing Act makes it unlawful to discriminate because of a variety of what are called protected classes. These are race, color, meaning color of your skin, religion, sex, meaning gender, national origin, like the country from which you're from, disability, and that has a lot of things that go in it, which we'll talk about, and something called familial status, which is what is a family, the makeup of a family. We also have now, via some case law that came down probably about 2 years ago, the inclusion of sexual orientation and gender identity as protected under the umbrella of sex. We used to, as if we were members of National Association of Realtors or our state local realtor association, have an ethical obligation under our code of ethics to include sexual orientation and gender identity, as well as if you're a member of NARPM, National Association of Residential Property Managers. But now sexual orientation and gender identity are mandated as protected classes as part of the law.
Perfect. Thank you so much for that rundown. In terms of specific statutes relating to the Fair Housing Act, can you discuss a few that are important that everyone should be aware of and just kind of know?
Absolutely. So I'm not sure if our friends are seeing slides on the screens or not, but if they are, then you should be looking at what is the actual Fair Housing Act itself. And basically, in a nutshell, the Fair Housing Act, there we go. The Fair Housing Act talks about whether that you cannot, if the first bullet there, refuse to rent or negotiate for rent or make unavailable a dwelling. The next bullet down is to discriminate against any person in the terms or conditions of rental, right? Like you can't charge an extra fee if you're in a protected class, or you cannot represent to someone that a dwelling is not available for rent when it actually is. And that 42 USC down there, USC stands for United States Code. So again, it's the federal law, the law of the whole United States. And I would add then, some states actually expand on this and have other additional protected classes. So this, again, is one of those things always very important to check with your local legal help in terms of municipality or state differences that may be there.
Perfect. And yeah, that's really great advice of just noting that sometimes there are differences in these statutes or additions made on. So it's really good advice to just make sure we're staying familiar with them and touching base on them.
Absolutely.
In terms of what you've seen just kind of recently, are there areas that HUD is trying to get more awareness around within the real estate community regarding kind of fair housing topics?
Definitely. It's sort of a misnomer to think that you don't have HUD enforcement actions, and these right here are really the three most prevalent: disability, familial status, and sex discrimination. When we're in, some people think, well, oh, we're in election years, or it depends on who's in the White House. That's not true. HUD is always very active in its enforcement actions. In fact, the head of all the enforcement has worked there for many, many decades. So regardless of our administration, there's folks and boots on the ground who are always working on these things. But disability, and we'll talk about that a little deeper in a minute, is always the top one because it deals with the issue of emotional support animals and or service animals. Familial status has gotten a lot of traction of recently because we sometimes see that HUD will hire what are called testers, individuals who go into a certain market and basically test a property manager or a real estate agent, a realtor, to see if there's maybe a no kids allowed policy or what is the accommodation for children. And then the most recent thing we've seen, and this is especially true of multifamily properties, is with sex discrimination, where we might have like an on-site maintenance supervisor or someone like that who's actually sexually harassing female tenants. A lot of that we've seen for any of my friends who are in the Texas or the Southwest area. There's been a lot of that as well.
Perfect. That's really good information on those kind of three areas of where to just keep your eyes on. And I like you touching on familial status. It seems like there's a lot going on there and just changes.
Very much so. Very much so. We can talk about that. Yeah, definitely.
Perfect. In terms of, this is kind of a similar question, but in terms of ways that someone can get into hot water with fair housing laws, do you see a few violations that are more common or that people are committing more frequently?
Absolutely. What's on the screen is definitely number one. Sick service animals and emotional support animals. 60% of all HUD complaints are disability related, right? And luckily, right at the beginning of the pandemic, HUD helped us with this kind of tricky area of service and emotional support animals by putting out a document, a guidance document, which is FHEO 2020-01. It's a real big deal for the real estate industry. After our presentation here today, if you want to go and look for that, FHEO 2020-01, it's kind of like a find your own adventure, Ben. It basically says, you know, you're presented with this type of situation, and what do you do, and what is that? Stepping back 1 minute, the difference between obviously a service animal and an emotional support animal is big. A service animal, if you think, you have to think about it as replaces actually some like bodily function or body part. The most obvious example would be a seeing eye dog, right? The dog helps be the eyes. Or if we have someone who has lost an arm or a leg, they may help the person be balanced, or they may help prevent seizures, right? So a service animal is literally a part of that person themselves. Most of the support animals are a little trickier because these are the ones that, you can go online right now and spend $100 and get a cute little jacket that goes over your cute little dog so you can take it into, the amusement park with you. But an emotional support animal is usually there to provide just that, some sort of comfort, helping with some sort of emotional or mental disability. Some of the examples we've seen of enforcement actions are things like a little boy who was autistic, who lived in the Chicago suburbs, and he needed a little pet rabbit, right, that he needed to pet. Well, his parents went to the doctor, were able to provide proof that the rabbit, right, was this little emotional support animal, and the landlord just said, nope, we're refusing it, they can't come in, and they ultimately got into a lot of trouble with HUD. So why? Why are they getting in trouble with HUD? Because of the fact, right there on the screen, that a service or an emotional support animal, they are not pets. They are not pets, right? They're replacing your eyes with the service animal, or they're helping like medicine would, right, when the little boy is petting the little bunny. And because of that, service animals and emotional support animals cannot have any extra fees associated with them. You can't, there's a no dog policy. That doesn't apply, friends, because why? They're not pets, right? You can't refuse them. But under this new law that came out in 2020, this new guidance, I should say, you can ask for verification. And HUD has even gone further to say, look, you can even question the source of the verification. Again, think back to this example of if it's a child that needs a certain type of, emotional support animal, most likely there's going to be a legitimate doctor, counselor, therapist saying why they need this, right? But again, under the new HUD guidance, we can actually question things like the $100 that I pay, just to get my dog into the grocery store with me. And it's also important to remember that while we can't assess extra fees with them, we can assess damages. If like the seeing eye dog, scratches up the back door, you can assess damage to any, or assess money damages or penalties to any damages that the animal does cause at the end of the lease.
Perfect. That's all really good information. I really love the examples too on the rabbit and how it's like medicine. Looking at the FHEO 2020-01 document, I know you were also saying in there too, it's also kind of like a checklist where it can be interactive for someone if they're looking to get some answers on like if it meets this, then that, and it kind of can walk them through getting answers around these kind of topics.
It's a fantastic piece of guidance from HUD. I mean, it doesn't actually say, here's what's going to happen if you don't do this, but it does give us it gives us a lot actually of protection as real estate agents, realtors, as property managers. It's also very helpful when talking to our owners, right? Our owners are like, I want no pets in this apartment, or in this house. And you can show them, look, here's what the federal law says. We don't have to accept everything willy-nilly, but we do have to give some consideration to what the federal government has said.
Perfect. So everybody, make sure you make note of that. Use that as a resource. It's a great resource out there. Just want to make sure we all pay attention to that. Moving on, in terms of, I know we kind of touched on this just a little bit, but in terms of familial status, could you kind of tell us what that is, how it relates, and just go into that a little bit for us?
Absolutely. The idea behind familial status is a family is a family is a family, meaning that HUD wants us as realtors, property managers, to not think that a family is mom, dad, and two kids. A family is grandma, sister, and two kids, uncle, nephew, grandpa. It's a variety of people who are related by blood or marriage that need to be given full consideration. It also is a prohibition to someone saying that no children are allowed at a facility, or making rules or regulations that would limit or affect children, right? So I'm not talking about friends across the country, like 55 plus communities like Sun City in Arizona or South Carolina. I'm talking about if someone just an owner says, look, I don't want any kids allowed, or if a homeowners association says there's no kids. The enforcement actions here are usually because someone has not allowed this, sort of however they view it as not a traditional family in. But we've also seen some enforcement actions where children have been sort of penalized. There were like rules put in about how loud only kids could be. And some of the remedies that HUD has ordered weren't even necessarily monetary then. They were things like, look, make it a better environment for kids, put in a playground, things like that. But it's got there's something about familial status with HUD that their eyes are on it. So we always want to be really careful about that and be, really thinking about, okay, just because it's not what we might consider a traditional family, it needs to be something that we're aware of because it is protected by the Fair Housing Act.
That's a ton of great advice. I know in my master's of education program, what they're telling a lot of educators around familial status is, in the classroom to be aware that there are different types of families now. There are blended families. Families look a lot different than necessarily what people considered, decades ago. So they really try to emphasize, at least to the educators, being sensitive to that. And it seems like HUD is also kind of in that similar vein of saying, hey, we got to pay attention to this.
Absolutely, absolutely. And again, that's why these classes are great. So applause to everyone who's on here. It's just a little bit more awareness to be able to understand, okay, how do we handle that? And how do we deal with our owners who may not understand?
That's so important. So, in terms of kind of fair housing missteps and when people make these, are there ways that people can kind of be, conscious of trying to avoid them or best practices to try to avoid fair housing claims?
Absolutely. And the first one unequivocally is you need to have a neutral process and protocols for onboarding tenants, deciding who will be a tenant, right? You need to run everyone through the same exact set of questions and information. When you are faced with a fair housing claim, they're going to look to see if you've treated all your applicants the same. If you have just a very standard form that you run everyone through, you're going to have great success in defending a fair housing claim. You also need to have as much training as you possibly can. This is an ever evolving area. So train on the issues that can be tough ones. For example, now that we have sexual orientation as something that's definitely protected as part of sex, we used to have to train on how do you explain to owners who would say, I don't want a same-sex couple. And you'd have to say, well, I'm a member of the National Association of Realtors or whatever. But now, knowing that we have training or that we have laws that will allow us to actually train our owners will make a big difference. You must, with fair housing, then have an escalation process. So if my brokers and owners are listening today, you cannot assume that everyone who's just manning your phone is going to know this, especially if you're using virtual team assistants. Be sure that everyone is very well versed on this so that they're not getting caught and you're not getting caught when someone calls up and says, well, I have a pet, and they say, I have an emotional support animal, and the VA says, well, there's no pet. Documenting what you're doing is always critical. As a trial lawyer for so many years, if I don't have a document, it's always hard for me to prove it. But documenting any issues you're seeing, and again, educating your owners, sharing that FHEO with your owners is a great thing to do. Sharing this webinar with them, but also, Ben, and you and I have talked about this, never be afraid, my friends out there listening, to fire your clients, right? I had a mentor once that said, clients are like buses. If you fire one or if you miss a bus, another one will come along, right? It is better that you let someone go who's not following your expert advice than get yourself into lots of trouble and have an owner point their finger back to you.
That's so true. I know a lot of times I hear people are always worried of firing their clients, but sometimes if someone poses a bigger risk to you than what they bring in, especially on a litigation side, sometimes you got to say, are they a match for my business? It's not always a question of, do we match for them? Sometimes the question is flipped around of, is this client right for us? And I think
Yes,
that's important for
exactly
us
right.
to know.
Yeah, it's exactly. We shouldn't be afraid of it. So yes, exactly.
Perfect. Well, let's switch gears a little bit. I know that we talked a little bit about property maintenance and legal liabilities that can arise here. So obviously, if you're a property manager, you're going to be responsible for working with the property owner to keep the property maintained, and you're going to be dealing with tenant concerns, complaints, requests for maintenance, things of that nature. So I know when we talked, you mentioned habitability as being a key term relating to maintenance and also just staying out of legal crosshairs. Could you talk a bit about what habitability is and why it's important for us?
Absolutely. And habitability is a legal concept that exists in all 50 states, and even outside of the 50, if you're in any of our territories, the United States territories, and you're listening. But habitability is having a residence that is safe and fit for human habitation. Ben, I usually say, think of it like this. If you wouldn't want your mother or your grandmother living in this house, then it's probably not habitable, right? And it really makes sense if you think about it. It's basic needs that every rental property would need to have, that we would need. For example, we need to have adequate heat. If I'm in Massachusetts today, I bet you it's probably cold there, right? You need to be sure that there's heat. If we're down in Texas or here in Atlanta in the middle of July, it's going to be hot. We need to have air conditioning, or at least adequate ways of getting cooling and heating. We always need to have clean running water. It's not acceptable to not have water that could be either both bathed in or be able to drink. Obviously, plumbing, we can't be having, yucky sewage and sludge like that in our home. And we also can't have a structure that poses an unreasonable safety risk. I mean, the most obvious examples are things like stairs without a handrail, right? Or we're always hearing about like the back decks collapsing, things like that. So habitability is safety, fitness for someone to live in, but even more simply, and even to your owners, would you put your mom or your grandma in there? And if not, it's probably going to have some issues.
I think that's such a great point, though, because again, it goes back to making us think as humans, not so much, as in a business mindset, but really as humans and saying, like, is this an environment I would want one of my loved ones in? And if you're answering no, you probably need to be listening to your gut and evaluating what the next course of, action is.
Exactly. And it's easy to do, right? I mean, none of this is difficult. It's just sort of common sense. But again, it's being sure that we're really always understanding that there's so much liability when we're not putting someone in that habitable situation. And it's so easy to prevent.
That's so true. I know when we were talking about habitability and just kind of the risks that are there, one of the things we talked about was constructive eviction. Could you elaborate on what that is? Give us a few examples of constructive eviction and just kind of what some of the common ones that you see are.
Absolutely. And again, for my friends listening from across, there's a lot of you I know from across the different states. Pretty much every state has this concept. It might be called something a little different, but the basic idea is that you as the property manager or as the owner has allowed the property to get into such a state that the tenant has to move out because it's just no longer habitable, right? You have, received complaints from a tenant and just have not taken the actions necessary to allow them to be living in a safe and habitable environment. So by basically like operation, they're evicted, right? It's not like you're evicting them for not paying rent. The conditions of the property make it so that they have to leave and can't be there. Probably the most frequent constructive eviction claims we see across the US, again, are things like utilities, no water, the HVAC not functioning, we've complained, we've asked for it to be fixed, it's not happening. Obviously, though, we have some very serious ones that can go directly even to, serious health considerations like lead-based paint. For all my realtor friends who are also on, who are maybe not property managers, you already know how we have such heavy regulations about lead-based paint. Talk about that a little more in a minute. But obviously, lead-based paint in the rental situation is also very serious. We also see with renting, Ben, a lot of things like what I'm going to call a dangerous environment. Things like you may have mold, which absolutely just flips people out with medical issues. And then also like maybe, rodent infestation, rats, squirrels, whatever it may be, that really get into the point of making the property so that people just can't stay.
So those are good, just three main broad areas that we need to be paying attention to. In terms of diving just a bit deeper into this maintenance category, I know we talked a little bit about those three right there, mold, lead-based paint, and rodents as being very common, as we just kind of covered there. In terms of starting with one, could we start with lead-based paint and just kind of go over what those risks are, how to connect it to an escalation plan, and just some best practices that one might want to utilize around handling one of these complaints?
Absolutely. So for my property management friends, we know that for years in the lead-based paint laws that the EPA had regulated, right, there was a frequently asked question, an FAQ. And within that FAQ, there was a directive that we've been relying on as the property management industry that we as property managers didn't have to be certified to do repair, renovation, remediation of lead-based paint. We could hire somebody who has that certification. About 18 months ago or so, EPA announced that they were going to delete or get rid of that FAQ. There was a lot of public comment put out, and that closed in, I think, then like the middle of December of 23. So this quarter, we're going to know, is EPA going to just get rid of that FAQ, which the reality of that means we are probably, as to be safe as real property managers, and really also as realtors, potentially if you're doing any renovation or rehab, get certified to be qualified to do those types of things. I'm told that you can get certified through state measures, through the EPA. There's classes that appear. We know, of course, though, that lead-based paint is so bad because obviously it's highly toxic, right? It's just what it sounds like. It's old paint that can be found usually in properties that are pre-1978. We also know, because everyone is probably a realtor, but we know that when we're selling houses, it's very, very important we have to have under the law, the mandatory lead-based paint disclosures, where we check the list and we basically say, is there any lead-based paint? Have we done this or that? And there are very, very, very high fines for lead-based paint. And this is true both for the lack of certifications for doing the repairs and renovation, but also if you're not attaching as part of a sale, as part of a transaction, the actual mandatory disclosure. It's $12,000 a violation. And it's important for my friends to remember that it's not all just the properties themselves. If the property is pre-78, what if it's a house that's been built in the last 5 years, but they've put in this beautiful bar that they brought down into the basement from an old country farmhouse, or they've gone out and they've gotten a mantle and put it over the fireplace. Those could be from pre-78. I've also seen HUD be very interested in out parcels, a child's playhouse, a little shed, right? So you have to really be thinking about EPA's wider net that they like to cast. And they are very busy, Ben, enforcing this across the country. In my travels, even in the last few weeks and speaking to groups, I've been hearing about that they're very active in my neck of the woods in the Southeast. They're very active up on in the Washington and Oregon area. And, they're literally going in, and when they do their audits, it's just tremendous amount of documents they're being asked for. And again, your liability is so high when it's so easy to just, one, have all those mandatory disclosures filled out right then when you're buying and selling or renting the property. And then, depending on what comes down with the certification question, maybe start thinking about getting one person in your company certified to deal with lead-based paint repair, remediation, and remodeling so that you don't have to worry about that. It's a very high profile industry because of how bad the effects of the poisoning of lead-based paint can be, especially to small children.
Those are all really great points. And I really like that you emphasize it's not just necessarily ceilings and walls. The emphasis on attachments and things that you either bring into the property or put onto the property that are dated pre-1978, the risks that they pose, especially because if I'm correct, when you're dealing with lead-based paint issues, it's strict liability. There's no, I didn't know, there's no, oh, I can, remediate the issue. If you're guilty, you're guilty, and that monetary fine is coming regardless of the circumstances.
Yeah, I've had very little success in saying, oh, we just didn't know, right? They're basically assuming that you as a licensed professional are aware of this. And then more importantly, Ben, your owners are expecting that they can rely on you as the licensed professional to get and to do what is necessary to get things done. But you're right, it's very expensive if you get caught in one of these EPA investigations.
Perfect. In terms of managing mold, I know we went over a few things, but can we do kind of a similar thing? Tell us what the risks are, how to kind of look at it and deal with it, and just kind of how you think about and approach dealing with these complaints.
Sure. Mold first really exploded on the scene for any of my friends who've been doing it for a while, really probably in the late 90s. And we learned really early on that it's not about mold, it's about the words that we use, right? So we like to, as the property management world, talk about it's not mold, it's mildew, right? Because let's be honest, everybody, especially if you have teenagers like I do, you're going to probably see a little bit of mildew in the shower in the middle of that. But mold, the mold that we need to be very concerned about is the very bad black toxic mold. The Stachybotrys is the most familiar one that people see. And mold it does happen, right? Mold as an organism, it needs to live on something, like that's why it likes sheetrock, right? Or paper. And then it needs food, which is water. So like I think about many of the cases I've had, the mold is found in, underneath a leaky toilet in a bathroom, behind a leaky washing machine or something like that. But mold really has become, because it's more prevalent in the media, and it's easy to Google. Tenants sometimes take advantage of this and overreact, right? But your reaction should not be one of underreaction, right? I always advise men, take the mold claims seriously, right? Go out, investigate it. If they've gotten their own little test, take a look at it. Did it cost $10 from the Home Depot, or did they bring a big industrial engineer out, right? Be sure that you have written policies within your property management company for how we control our reaction. What do we do when the tenant says this? How do we handle it? We also want to also consider always having some sort of tenant document that lays out what they're supposed to do, right? Honestly, I don't like seeing my property managers be hit with, oh, I got this mold test. The policy, the written documents we should be using with our tenants are things that will say, okay, if you think you have it, you call here, you do this, right? And then internally, you have that procedure and checklist as to what to do. Mold is also one of those areas that, again, even if you're like, it's mildew, you're blowing it off, you have to assume it could be bad, because if mold really is there and prevalent, it is linked and can cause some serious injuries, especially to people who already have pre-existing things like asthma or any kind of upper respiratory, to small children, things like that. So it's one of those areas too, Ben, where you can't be afraid also to maybe spend a little money, right? If it does look like there's mold within an apartment, maybe, or I'm sorry, within a rental home, maybe it's time to decide, okay, I think we need to get these tenants out for a few days. This is when you put them in an Airbnb or get them into a hotel, give them a couple gift cards. You are better served, right? Spending a few $100s getting these people out of what could be harm's way, and them coming back later and suing you and your owner for saying that you didn't properly react to the mold and treat the mold. So really, first and foremost, there's got to be written policies and then internal procedures for escalation, just like we talked about with fair housing. When there's a mold claim, who gets that? That shouldn't be your most inexperienced staff person. Those things need to make their way up to the senior property managers, the owners, or to the broker and owners of the company themselves. Mold is not a joke, but there are some people who try to take advantage of it. There's a lot of lawyers out there who try to take advantage of it. Here in the Southeast, we actually have a law firm that's called the Mold Lawyers. So, I mean, they're just trying to get people to come in and, say that they have claims, when some do, some don't. But it's a very hot button issue, even though it's been around for so many years. So we always want to treat it very seriously.
I like all those points there, and I especially like your point. It kind of goes back to not being afraid to fire a client. Don't be afraid to necessarily spend a little bit of money to mitigate a risk, to make sure that you're not causing a bigger issue down the road, and really being conscious of when it's appropriate, to take measures of that kind of seriousness to a little extra length, just to cover, from worse outcomes down the road.
Exactly right.
In terms of rodents, I know we talked a lot about how they're different from pests, and based on that, there's a few things that distinguish them and ways that you should kind of approach remedying the situation when you do have rodents. Could you kind of talk about rodents versus pests and just kind of how to approach those?
Sure, absolutely. Now, again, this is going to be one of these topics that you may have your own local, municipal, state, county ordinance as it relates to the responsibilities of property managers in dealing with rodents or pests. But normally, legally, we think of pests as being like bugs, right? Insects. And pests being the responsibility of a tenant, right? Pest control, getting rid of, here in the South, we have cockroaches that they call palmetto bugs. Same thing, everybody, it's still gross. But rodents are a different story, right? Rats, squirrels. This is something that can really, again, be very not just dangerous, but go to habitability. It can be really gross. And really, at the end of the day, your property owner is responsible for this. They need to be understanding that, you have to be vested as the property manager with the authority and the tools to be able to eradicate a rat problem. And you, as the property manager, can't really rely on, oh, well, I told him this, I told him to do it. I tell many people have heard the story, and I won't go into great detail, but it's a story where the property manager got into a lot of trouble when there was a rodent problem that wasn't fixed. And the judge looked at the property manager and said, I don't care that the owner didn't fix it. You're the licensed professional. You're the one that knows better, right? So why didn't, said the judge, why didn't you call critter control, take some action? Rodents are a habitability issue, right? It's gross if we have these kind of environments in kitchens and bathrooms. This again is one where your reaction is very important. You don't want to flip out, right? But you do want to get to your owner and you want to press your owner to do what's right. And you also want to have written policies and checklists within your staff, because someone calling one time about a rat is different than someone calling like 4 or 5 times about rats, plural. And again, not taking the proper action and documenting it is what gets us in trouble down the road. But I think rodents are a really good example of where you, as the property manager, really need to do what you think is right, even if the owner is saying it's not that big of a deal, or oh, they live in this city where this is prevalent. You better be, pretty sure as the property manager, you are confident in telling your owner what they need to do, because again, these issues go directly to habitability. And again, when there's no habitability, you get into lots of trouble as a property manager, and then your owners get mad at you too.
I love that distinction too of making it clear you are the professional. While they are the property owner, you are the professional who is meant to be bringing the expertise and advising them on how to handle situations. And it kind of segues into our next topic, which is how do you deal with owners who refuse to repair things? So could you briefly just kind of advise us on how to handle owners who maybe don't want to, or how to approach them when they're kind of being resistant to making maintenance, upgrades and things?
Yes, absolutely. So here are the things that I'm told that my property management friends hear. They hear things like, well, it was fine when I lived there, right? Someone's complaining about, no hand railing on the banister, right? Just put a Band-Aid on it, they say. I'm just put out some traps. It doesn't matter that they saw 20 rodents in the kitchen, just put out some traps. You don't need to call the exterminator. Oh, I don't like that estimate. It's going to be how much to, fix that mold problem in the basement? Shop around, right? Or they turn it around and they blame you. They say, well, I thought you were supposed to be going in there and looking to see if there are any leaks or problems like that. So when you get that type of reaction from an owner, you need to be, this is where your documentation friend comes in and makes such a difference, right? You need to always be responding to your tenants in a timely manner, but you also need to be sure that you know the right time to bring your owner into the mix, right? I have some property managers who immediately tell their owners everything that's there, but then I have others who wait until it's, a bigger issue. I think that again comes with training and time, but you want to be sure no matter what you're doing, you are always responding to that tenant in a timely fashion and documenting it. Ben, so many of our great softwares that are out there for the property management industry allow us to do that, have that calendaring and follow-up of maintenance requests. Once you get to the point where the owner has to be involved, you want to be absolutely sure that the owner in any way is giving you sort of any of those comments above about, oh, it's fine, or I don't want to do it. You need to press them to resolve it, because again, you as the professional know where it could lead. What happens if we have unchecked mold? What happens if they don't, want to spend a couple $100 to put these people in a hotel to fix the issue? And then finally, just like firing a bad owner or an owner that won't listen to you, I always think it's better to respond without your owner's permission. The owner is fussing about an estimate, right? That's, he'd rather pay $250 than $375. Go ahead if you know the $375 is better. You can either fight with your owner later about that extra money, but I would rather you always fight with your owners than with the tenant. And Ben, we'll talk about this a little bit in the next section, but we've got to always be conscientious of the idea that an owner is very different than a tenant in terms of how a court would look at them and the power that they have. So sometimes owners just don't know best. We have to assume that, again, they've hired us to be the professionals and do the right thing. So if you have to respond and make that repair to habitability without their permission, don't be afraid to do it, friends. Do it, and I'd rather you fight with your owner later.
That makes a lot of sense. It's kind of like the principle of, instead of asking for permission, ask for forgiveness on some of these things, because you are the professional, you know what the ramifications are. And as you said, instead of fighting with the tenant, it's better to hash these out with the property owner and not have a legal nightmare on your hands, that kind of bruise that could have been avoided.
Exactly right. Exactly right.
Perfect. Switching gears a little bit now, we're going to get into property management agreements and leases. And I know when I saw you in NARPM back in September, you and Robert did an excellent job discussing ways that people can strengthen these type of agreements and leases. I know we don't have time to review everything we discussed there and going over the body armor of leases and agreements, but one topic that you mentioned that stuck out was legal lease. Can you go into that a little bit and just discuss why it's important to our leases and agreements?
Absolutely. Legalese, everybody, is all that garbage at the end of your property management agreements and your leases. And for a second, don't read the screen. Just look at me, everybody. Or I say to my little kids, look at me, okay? But this first idea of legalese is what's on the screen, but don't read it. Listen to what I'm saying to you. It's that concept of an entire agreement clause. This is in probably every legal document you have, whether it's your credit card, agreement to, your car lease, whatever it might be. This is the idea that the agreement, the actual four corners, the document itself, right? This is the entire agreement. So what might be on my website, for example, if I say I'm going to come in and on the website, we inspect every month. If it's not in this document, right, under the law, it doesn't matter, right? We can't say that a sign that was sitting out there, well, the sign's not attached. We used to use for my real estate friends the idea of if it said like, newly remodeled or it talked about things about the houses. Well, if those signs aren't in this document, it just doesn't apply. So here's an example you can look at later of a really good entire agreement clause that we would use, say, mostly in really could be used in both, a property management agreement or an actual lease itself. But it really just makes the concept that what the parties have agreed to, that made it into the document, if something goes south, that's what they're going to be fighting over. No statements outside of that. No emails, flyers, or conversations that are there.
Those are really good points. And I think it goes on a trend that we've kind of been talking about relating to our earlier topics of documenting things, having things in writing. When it goes to your leases and agreements, same thing. If it's not on the lease or agreement and it doesn't exist in those four corners, it's not enforceable and it doesn't exist. So we got to understand the importance of writing.
That's right. So much so, so much so.
Taking legalese just a bit further, are there a few areas that people should be aware of or know how it relates to their leases and agreements, or maybe language that they should consider adding in there that would help strengthen kind of their agreements?
Absolutely. And actually, what you just said is exactly perfect. It's that concept of what's in writing. So again, I know we have folks from all across the U.S. listening. Virtually every state has some form of what's called the statute of fraud. It's not about fraud like committing crimes. It's the idea that there are certain things in life that just have to be reduced to writing. It comes from the old English law. Remember all of our law in America, even Louisiana, my friends down there, you have some Napoleonic stuff, but everybody's got some ring back to English law, and that's with property. And so the idea with all of that is it's the concept that there are some things with real estate that just have to be in writing to be enforceable. Renting property for a certain amount of time in most states has to be reduced to writing. Buying and selling property has to be reduced to writing. But where statute of frauds comes in a lot is very similar to the entire agreement clause, where somebody says, well, I was promised this or I was promised that. Well, an argument legally that our laws, our statutes on what needs to be in writing may actually help protect us as realtors and property management managers if we aren't having something that must be in writing that would be enforceable. The other thing that, again, I would really encourage you to be very familiar with in the documents you're using. I applaud you if you're using your own documents that you customized, but I also applaud you if you're using your state's real estate association documents. You've always got great think tanks behind those documents. But remember in that notice provision that's going to be in all the leases and all the property management agreements, where is notice supposed to be, right? Back in my day, we had fax in there. I bet you fax, maybe in some, not anymore. But, email, text, these are all very, more modern things, especially text. So be sure you're always following and are aware of what your official notice method is. Don't be texting friends if your official notice is actually an email, or if it's more, more older or aged, it might say, UPS or certified mail, right? So you always want to be sure that you're just paying attention to the small legal details, like how is notice properly given? Because sometimes how notice is given can make a huge difference in a case as to whether you win or lose, or did you follow the steps properly. Also, be sure you understand, and this is one of those things where, I can't sleep at night, but take a read of your property management agreement, right? What does that do? Because that's you as the property manager and your owner, right? That's that agreement. That's that relationship versus what does your lease do? That's your obligation to the tenant. And whether you're the whether you're the landlord as the property manager in the lease, or your owner is the landlord in the lease, it's still that idea of the obligations that are there with, with the tenants themselves. There will be certain legal things that will be different in those because of the balance of power between an owner and a property manager and a tenant and a property manager. So we always just want to be being sure we're taking, good reads of our documents if we haven't done that, in a while.
I really like your point too on it's not just everything in writing. It's everything in writing in the appropriate manner as outlined in the lease, because not all types of writing are equivalent when it comes down to enforceability and looking at did you do the steps appropriately and handle it.
Exactly. And again, I know we're sort of broken records. You and I have been on this, but the owners will come back and look at the licensed professional. They just will, right? They're going to say, wait a minute, we can't get that tenant out because you didn't give the proper notice. You sent it via text and the real form is, via an email or a hand delivered letter. So we forget sometimes how these little tiny things can really make big differences. And again, it'll come back onto us as the licensed professional.
That makes a lot of sense. Kind of piggybacking on the importance of everything in writing. You mentioned exculpatory language that can be a good strategy for strengthening our agreements. Can you kind of go into exculpatory language and just also some of the areas that one might consider using it?
Absolutely. So exculpatory language, friends, is basically, put another way, like CYA language, right? It's basically language we find in some contracts. And again, this is definitely one where you're going to want to be sure you're relying on your local legal expert in terms of your state, your county, your municipality, city laws. But basically, it's the idea that can I have hold harmless, or can I have language that says you can't sue me in your various property management documents? This again is where it's very important to remember what document we're talking about, right? You obviously, with a tenant in a lease, can't waive habitability, right? The tenant can't say, I agree not to sue the property manager or owner if there's no running water or no air conditioning in the middle of August in Texas, right? You can't do that. That's against every single state's law. And in some states, municipalities, it's even heightened what you can and cannot do. But there are certain states, in fact, the vast majority, will allow you to limit or cap your damages. This is especially true, friends, as it relates to the property management agreement, right? Again, we've mentioned this, but let's just kind of get another visual picture. If I'm in front of a judge, right, I'm up here as a learned licensed professional. I've been on all these great rental beast, webinars. I know what I'm doing. And, my little tenant is maybe just like a little college kid or somebody who, just doesn't know really what's happening, right? The law is going to see you, and the judge is going to see you as at a much higher level of knowledge and application than they might the tenant, and always give the tenant more leeway, right, as it relates to things like waiving liability or limiting damages, et cetera. But that's different, right, when we have our owners. Our owners are considered sophisticated business people that at least they're supposed to, right, guys? Know what they're doing and all that stuff. So a judge will look at the laws and we'll look at your agreements when it's between an owner, right, and a property manager much differently. Limiting or capping damage, for example, the documents that I create for folks, we limit it to 1 year's management fee, right? So if you want to sue me for something, go ahead. Usually we limit it to things like just gross negligence. You can't say I can, not repair broken steps that I know about it. But if it's gross negligence, right? You could if it's not that, you could limit, right, or cap what your damages may be, and that's often very successful. Maybe, yeah, you are guilty, you didn't do something, or liable, I should say, but you can limit what you have. Many states and many forms from the State Realtor Association have both mediation and arbitration clauses. Mediation, of course, non-binding pre-litigation or during litigation settlement conferences, versus arbitration, binding. Instead of going to court, we go to arbitration. I think NAR in particular has this in most of the state generated forms. NAR is a big proponent of that. But again, it's ways to just sort of limit the liability, keep the costs in check. But again, friends, please be sure you're familiar with your state's laws, rules, and regulations on what can and cannot be waived. Because in some states, especially on the West Coast, you're not going to be able to waive or limit or cap things. But we have other areas of the country where you're absolutely able to do that. And we find that it's done with great success.
Those are all great ideas in terms of limiting your liability, making sure that maybe you're setting the favorable ground for where a legal contention or battle will go to in terms of what you're set up to want to handle. A lot of those are good. And I also like the point, I know we've talked on this a little bit, but the different tiers at which the court looks at the parties involved and understanding you are at the highest tier. You are the professional there. They're going to be looking at you. So we've got to be protecting ourselves in that world.
Yeah, absolutely, without question, without question.
Well, Monica, this was all a ton of really great content. We really appreciate you coming on here. For people who want some next steps to keep moving forward and kind of momentum, do you have a few suggestions that they could kind of take from today?
Absolutely. And I would encourage you, if you have staff, share this with them. It's a great way to maybe start off a meeting on a Tuesday and just, run them through this. But you should always within your office and within your practice create and, be sure you have escalation protocols, right? If a phone call comes in that someone can't answer on emotional support animals, where is that call going to go, right? And not being afraid to quickly escalate if you need to. Also, I would also take time, again, I know it's kind of a snoozer, but I would review your lease and your property management agreement at least once a year for vulnerabilities. Laws change, your state laws may change, your municipality laws may change. You may go to a class like this and say, wait, maybe I can add that in. And then fair housing, I know that I harp so much on it, but fair housing training is so critical. And I would really commit to 24 being the year that you do quarterly training, right? Maybe take each protected class in chunks, go through it. Be sure your April is Fair Housing Month. Be sure you're looking for Rental Beast or other places that are maybe doing fair housing criteria, and be sure you share it with everybody in your office, right? Especially your remote team members. That's probably one of my top tips, is share this information with the folks who aren't sitting right in your office every day. Be sure everyone in your office, A to Z, is aware of all these different ideas that are out there and ways to limit your liability.
I love that. So to recap, we're reviewing our escalation protocols or creating them. We're looking at our leases for vulnerabilities, and then we're also committing to make sure we stay up to date with training, and let's be sharing this content. This is content that we encourage y'all to share. We'd be happy for y'all to do it. So if there's colleagues, peers that you think would benefit from it, let's get it out there and make sure that they're also protecting themselves and avoiding legal liabilities. So we're going to open up the floor now for a couple questions and answers. And I was looking at the chat as we were going through, Monica, and I already had kind of flagged one to the side here that I saw a couple times. But what do we do if the emotional support animal is what's considered a vicious breed, like a pit bull, and the HOA doesn't permit them to be there? How do you kind of handle something like that?
That is a great question. Yeah, so let's say you're managing a house at an HOA, and the HOA covenants restrictions say, no what they call vicious breeds, and they list out certain types of dogs that they think are vicious, pit bulls, whatever, German Shepherd, and suddenly in comes an emotional support animal that you can verify is valid, and it's a pit bull, right? Go back to that slide where it said an ESA is not a pet, right? So you're going to have to go to your HOA and explain, look, this is not a pet, right? Yes, this breed is banned, it's something you don't want within your covenant, but this is not a pet. This is actually a medical device for this individual. And again, with HOAs in particular, homeowners associations, you may have to educate them a little bit, but that would be an example of it doesn't matter what it would say in those covenants, the federal law would control over that. And the dog would be let in, or the
That's
ESA would be let in.
sorry. I also saw someone ask about number of emotional support animals, and if there are more than one, is one more credible than the other? How does that kind of work if there's two emotional support animals?
That's a great question. I actually just answered this for a client last week. Yeah. And here I think it's just a question of, they both have to qualify, right? You have to run both of them through the proper screening processes. In the case I talked about with my client, we felt pretty comfortable about one, right? One was linked back to a medical doctor who said, here's what's needed. The other one had the little $100 thing that they bought so they could take it. I would use my example of Epcot when you're in Florida. You see all these people with their dogs and they're drinking around the world, and you're like, that is not an emotional support animal. That dog is there to drink beer at Disney World. But yeah, you just because they have more than one, I don't think it lends credibility either way, but you have absolutely every right to ask for qualifications for both of them. And if one doesn't pass muster and the other does, then you say to them, look, dog one, that's an ESA, or, dog one is an ESA, but dog two, you're going to have to go through the procedures and then go further. What if it's a no pet policy? Well, the ESA can come, but number two that didn't make it, they can't come. And that probably will solve your problem anyway, because then the tenant will probably look elsewhere since both dogs can't come. Good question.
Yeah, I saw that one a couple times. So I know we had a few people who were interested in that one. So I'm glad that it was relevant in the sense that you were fielding this recently too. So it seems a lot of people have some questions there. Another one that I kind of saw that was kind of being asked, and I saw it in kind of two different ways. One was if a landlord doesn't ask about an emotional support animal on their application, should that be reported? And the vice versa of that I saw was, did tenants have to disclose an emotional support animal on their application to a landlord?
That's a really good question. Yeah, I would advise having as part of your application just a simple question. Do you have, well, either do you have any pets, right? If it's a pet friendly and allowed property, or flat out, do you have an emotional support animal? Now you cannot ask, do you have a disability, right? You can't ask that, right? And even if they say, yes, I have an emotional support animal, you can't go, well, what for or how come? You then would be able to say, though, okay, I need your proof that it is in fact a valid emotional support animal. And remember, people that are doing it right, this is not going to be an issue, right? They're going to have like the little boy with the bunny. They're going to have the letter from the doctor, and it's all going to be fine. If though they're coming up with something that's monkey business off the internet, then that's something different. But yes, I would advise. If it's a property that won't allow pets, period, then I would keep it limited to, do you have an emotional support animal, yes or no? And then if they say yes, you would go through whatever your procedure is from there.
That's great advice. So it's kind of like it depends on what your situation is on how you should approach that with having it on your lease and how you kind of want to put the verbiage on it, so to say.
Right. Right. I mean, again, if you're leasing properties where there are no pets allowed, then someone's going to say to you, hopefully, I have an emotional support animal, and your response is going to be, well, okay, I know that they're not pets if properly certified, right? People should, though, be disclosing that. I would think, again, not to be rude, but I think someone who has a legitimate emotional support animal should be very, that'd be like saying, I need a ramp, I'm in a wheelchair. It's something that helps them live, and you would think they would advocate for themselves and let you know that up front.
That's smart. That makes sense. Like them being direct with what their needs are, and letting you know as well. In terms of, I saw a couple questions here. I'm going to give you some real quick rapid fire on habitability, but there were three that stuck out to me that I saw. One was saying, can you limit how many people are inside a unit? The next one was, could you go over HOA and kids again? Because he spoke a little fast. And then the final one there is, how does it apply to a group home where rooms are being rented out to individuals?
Sure. So the first and the third, the number of people that can be in homes, are absolutely governed, usually by your city or county or municipality law, right? So that's one that often bumps up with that familial status too with fair housing. But like here in Metro Atlanta, right, we have one county where you can't have more than, like, I don't know what it is, but like 3 unrelated people. So like that would forget like a bunch of college kids sharing a house, something like that. So those rules are very dependent upon where the property is located. And the reason why they try to limit those is because of habitability. They don't want too many people in one place. There's also rules in certain areas of the country, especially the South and Southwest, about boarding houses, that those are sometimes regulated by the county or the city law. In the middle, I'm sorry if I went too fast, about kids and HOAs. I think what I was saying was we've had scenarios where we have properties who try to say that they're adults only, but they're not actually doing their paperwork correctly, right? It's homeowners associations who aren't falling into the criteria of like a senior community, right? And again, I handled a case many years ago where the condo association just said no kids allowed, and under the fair housing laws, that's just not legal. You can't do that. So sometimes, again, you need to, as the agent, go to the HOA and explain and help educate them on what the law might be.
That makes sense. I think we got time for one more question, and then
Sure.
Monica's got to get out of here. I saw one on here that I think we might be running into more with the changing of kind of the rental climate. But could you explain how fair housing issues affect short-term versus long-term rentals?
Oh, that's a really, really good, wow, that's a good question. Obviously, in terms of long-term rentals, fair housing absolutely applies, right? I'm trying to think if there's an equivalent of fair housing to short-term, because short-term would be similar to just, you know, general discrimination of services, right? It'd be no, like, remember, short term is the equivalent of, like, the Marriott, right? Well, the Marriott is not going to be able to discriminate against you as a business, right? For certain protected classes. So my advice, if you're dealing with short-term rental, is be equally aware of what those protected classes are. And when it comes to disability, that would be another one, right? Like, if the short-term renter comes in, you say no pets, but they've got an emotional support animal, great. Where they say, I need accessible property. Again, remember, with accessibility issues, it's reasonable accommodations, right? If this is a fifth floor short-term rental in New York City and there is no elevator, right, it will not be reasonable to accommodate someone who would need a wheelchair, right? And so the law gives you a little break from that perspective. Well, that's a really good question. And, in short-term rental, pretty much everything we said is going to be applicable in many ways to it, but that's another actually great topic to talk about. There are a few differences. But with fair housing, without question, I'd have the same rules in the back of my mind.
I love that. And reasonable accommodations, really understanding how that relates to something, it sounds like is a key factor here. So,
Definitely, definitely.
well,
And Ben, I think you and
Monica,
I talked about that if we had questions we couldn't get to, there'd be a way to potentially have me address those. Is that right?
yep. So
Great.
we will pass those questions along, folks. I know we had a ton of questions. If we didn't get to all of them, Monica is going to be gracious enough to maybe give us some extra kind of tips after the webinar on some of those questions. So be on the lookout for that. This was recorded. You will get the slide deck. We will be sending that out. You will receive that. So for those of you who were concerned on that, don't worry. We'll get all those assets to you. Otherwise, Monica, thank you so much. This was such a valuable webinar for us. We really appreciate your expertise. So thank you, thank you, thank you.
Well, thank you, Ben, and thanks to Rental Beast and all the sponsors for letting me come today. I loved it, and I can't wait to come back again.
Thanks, Monica. All right, everybody, have a great afternoon. We'll see you next time.